Good morning, honorable members. Good morning, the staff of Parliament. And good morning to members of the media. And a very good morning to our guests. Good morning, Honorable Ntuli. Good morning, Honorable Sokanyile. Good morning, Honorable Skosan.
Good morning, Chair, and the compliments of the new season.
Good morning, Honorable Shongwe.
Good morning, Chair, nabasebenzi basekhaya bonke.
Good morning, Bangazita.
Goeiemôre voorsitter.
Goeiemôre, meneer. Good morning, Honorable Sols.
Good morning, Chair, and compliments of the new season.
Thank you so much. Good morning, Honorable Breitenbach. Good morning, Honorable Kola Barnard.
Good morning, Chair. Compliments of the season.
Good morning, Honorable Cameron.
Good morning, Chair.
Good morning, Honorable Thopper.
Good morning, Chair. Compliments for the new year.
Advocate Arense, good morning to you.
Good morning, Honorable Chair, Honorable members, members of the media, members of the public. Good morning.
Advocate Mkhwaiz, good morning to you. Do you have a microphone here? When I say good morning to you, I want you to greet South Africans. When I'm sitting here, I'm representing the Republic, so it's not me saying good morning to you, it's the Republic saying good morning to you.
My apologies, Chair. Good morning, Chair. Good morning, South Africa and honorable members.
Thank you so much, Advocate Mkhize.
Good morning, Chair. Good morning, honorable members and South African.
Thank you so much. Who is representing the staff of Parliament here, or who is leading the delegation from the staff of Parliament? Good morning, Nicolette van Zyl. Greetings to you.
Good morning, Chair. Good morning.
And extend those greetings to all members of your staff.
Will do.
Okay. Mokhalaka, good morning and welcome. Good morning, Honorable Matthys.
Good morning, Chair. I know you missed me, so it's extra good morning to you.
Thank you so much. I'm greeting Honorable Tambo and Honorable Pambo. Good morning to you and welcome. Honorable Matthys, may you please introduce the honorable member sitting next to Honorable Pambo.
That's our national chairperson of the Economic Freedom Fighters and the EFF's chief whip in Parliament.
She's Honorable.
Honorable. Mam Nontando. I'm so used to calling her Mam Nontando that I'm even getting confused.
Honorable
Nonchungu.
That is the surname. Honorable Nontando.
Good morning, Chair.
Good morning and welcome. It's a convention in the proceedings of this committee that when a member of the National Assembly or any House of Parliament joins us, we introduce them. So we accordingly introduce you that you, for this moment, have joined our proceedings. General Phahlane, good morning.
Good morning, Honorable Chair, and good morning to members.
Thank you so much. Is there anybody you want to introduce to us?
Chair, I'm with Advocate Setene my counsel behind me. I also am with Advocate Johan Extian. Both are here to support me.
Thank you so much for the introductions. Honorable members, this is a new year, it's a 2026. And before I make any remarks, I'm going to give your parties, each one of them, 2 minutes to greet the people of South Africa. Can we start with the African National Congress?
Good morning, Chairperson. Good morning to all honorable members who are here. The Senior Counsel and the team, General Phahlane and his team, the staff of Parliament. Maybe, Chair, I should also take this opportunity to convey an apology on behalf of.
We will come to the
we'll come to
apologies.
the apology. Okay.
Just greet South Africa.
Okay. No, thanks. And good morning to all fellow South Africans and compliment for the new season. Thank you very much.
The MKP.
Ngikuthokoze mgcini sihlalo bahayithu bonke abantu abasithumela eParliamente ekulu njengoba sila ku Ad Hoc Committee ngibalotshisa bonke ephasini mazombe ngithi ingathi unyaka lo ungaba unyaka ozokwenza ukuthi unite kube mnandi eSouth Africa kulungise imthapho le esenze ukuthi sifike la sikhona ngithi namakhosi bafundise amakhosi ngithi bayede wonke umuntu okhona ngapha ngephasini siyabalochisa njengomkhonto wesizwe ngiyathokoza.
Thank you. The Democratic Alliance.
Good morning, Chair. Good morning to the members. And good morning to everybody who holiday appears to be over and is now watching this committee. So Happy New Year to everyone.
Thank you so much, Honorable Breitenbach. The EFF.
Morning, Chair and colleagues, and General Phahlane and your colleagues. We send our revolutionary greetings to the people of South Africa and wish that all those who are unemployed get their jobs this year and it becomes a very successful new year, especially for the poor of the poorest. Thank you.
The IFP.
Well, thank you, Honorable Chairperson. Greetings to colleagues, the honorable members. Greetings to the Senior Counsel, Advocate RNC and his team. Greetings to the parliamentary staff and also to General Phahlane and his team and to fellow South Africans out there. And I do want to take this opportunity to also congratulate our matriculants for such an outstanding performance. I thank you.
The Patriotic Alliance.
Nwenkia Ahuniki, South Africa. God has entered the ring. Thank you.
Thank you so much, honorable members. I afforded you that opportunity because I know that during the Christmas break, you met many South Africans who look up to you to represent them in this parliament, and some of them would have appreciated the work that you do. Others would have given you advices, and others would have raised their hopes with you, their expectations, and how they may want you to deal with matters that afflict their lives on a daily basis. I want to thank you so much for those messages of goodwill that you have given to the people of South Africa. We are going to move to apologies. We have received apologies from Honorable Sangoni and Honorable Ngola, as well as Honorable Vessels who are having family commitments. Today is the day of the reopening of schools in the Republic of South Africa, and parents who have children who will be registering or appearing for the first time at school today have to accompany them to their respective schools. And that is basically why those honorable members will be joining us later today or tomorrow. Honorable James has her flight delayed. She will join at the time she arrives. And Honorable Breitenbach has requested to be released at 18 hours this morning. And tomorrow as well, she has an appointment which may take her out of the proceedings. But she has promised that she can send someone to bring her photograph here. We will see as it comes. Honorable Breitenbach and Honorable Thopper as well has spoken about personal commitments tomorrow. Can I check further apologies, Honorable Skosana?
Thank you, Chair. Honorable Nomvalo will join us in the next few minutes. Yeah.
Okay.
Thank you.
Do we still have further apologies? Okay. Honorable members, we have two witnesses this week. Today, we have a date with General Phahlane, and then tomorrow it will be Lieutenant General Khumalo until Friday around 2 o'clock or 15 hours. And then next week, Tuesday and Wednesday will be the appearance of Mr. McBride. And then Thursday and Friday will be Mr. Julius Mukwanas. The committee will meet on Monday to finalize all outstanding matters as we are working towards winding up towards the date of the 20th of February. General Phahlane has requested that because they had a hectic time preparing for the statement that has been made available to us of about 170 pages. The request is that we run until 20 or 21 hours tonight so that they can have time to rest. So this is a matter which committee members must think about as we proceed during the day. Committee members have any feedback that they want to give to the chair, you can always advise. In case by that time we are not finished, we can decide on Monday when do we reallocate him a day to come back to conclude the proceedings. But like I said, we are a committee, we are here, all of us, we can always advise each other as the day progresses. I think it's a fair request. Let's allow the proceedings to go ahead, and we will make that determination as the day progresses. Can I check Advocate Arendse? Do you want to formally introduce the witness?
Thank you, Honorable Chair, honorable members. Good morning, General Phahlane and your legal team. We have formally met each other also this morning, and we've been engaging with General Phahlane and his team over the past few weeks. And the affidavit that is now before the committee with the annexes is the result of that lengthy engagement. General Phahlane obviously wants to use this opportunity of clearing the air and raising a few issues on this platform, and it's his right to do so. So he is here today and willing and prepared to give his evidence. So I formally request you to swear him in as a witness. Thank you.
Okay. Maybe before we swear him in, may you kindly introduce the advocate next to you formally to the people of South Africa.
Thank you, Chair, honourable members, members of the media, and members of the public watching. On my left is Advocate Bongiwe Mkhize. She's a member of the Johannesburg Bar. She was appointed in early December to assist us in place of Advocate Lerato Sikalala, who has been with us up until the end of November, and due to prior commitments that she has during the course of this year, starting early this year, she was unable to continue. It's a big loss to the team. But in the short time that we've had with Advocate Mkhize, she's a more than able replacement. So I've already introduced her online to the Honourable Committee, and she's here in person today, so we welcome her on board. Thank you.
Advocate Mkhize, we welcome you to this committee and these proceedings, and we want to wish you all the best in the responsibilities that have been allocated to you. And in the same breath, we want to thank you, all of you, Advocate Zikalala, Advocate Mokhaitz, and yourself for raising the flag in the name of the women of South Africa, that women are capable, women have abilities, and they can do everything to realize the aspirations of the people of South Africa. All the best to you. Thank you so much. I nearly said Advocate, Honourable Malema.
No, thanks, Chair. And I'm sorry to come late on this point. When you dealt with apologies, you said people have taken their children to school. And an option we thought we didn't have. Because had you communicated something like that before, we would have done the same. We're sitting here painfully that we have not accompanied our children to school because we thought such an option was not available. But now I hear that
I said those children who have today as their first day at school, and I know very well that you and I do not have children who have to start school today. They have been there, they are used to the environment.
No, you don't know that.
Yeah, no, it's not that it's an option, honourable members. They have made those requests that they accompany their children to school. General Phahlane, are you ready? Can we administer the oath?
I'm ready, Chair.
Thank you so much. Let me just read the following to you, which is a standard practice that we do with every witness that appear before this committee, that you have been invited to appear before this ad hoc committee to investigate the allegations by Lieutenant General Ntanta Mkhwanazi. You have been invited here to provide information in relation to the ad hoc committee's oversight work in investigating the aforesaid allegations. They include, amongst others, the alleged unlawful disbandment of the Political Killings Task Team, otherwise known as the PKTT or NPKTT. Number two, the alleged moratorium on the filling of vacancies within the South African Police Services, the SAPS. Number three, alleged corrupt relationship between senior leadership within the SAPS. And lastly, alleged political interference in the work of the SAPS. When this invitation was extended to you, you were accordingly informed that you may provide this information to the ad hoc committee if you so wish, under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act. We want to take this opportunity to inform you that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. General Phahlane, however, you are protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or a Committee of Parliament with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. General Phahlane, you are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take the oath or the affirmation. Which one do you elect?
I take an oath, Chair.
If you take oath, then you will follow me as I dictate. You will say I and state your names in full.
I, Johannes Khomotso Phahlane,
swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth. And so help me God.
So help me God.
Thank you so much. I'm handing over to you, Advocate Arendse, to take us through the proceedings until 13 hours. During the proceedings, General Phahlane, if members of the committee want to clarify certain matters that you would have made in your statements, they are allowed, and I think it's something that you must be alive to. Thank you so much.
Thank you.
All the best.
Thank you. Good morning.
Good morning. General, a fairly lengthy affidavit has been made available by you to the committee. And there's a number of issues that has been raised by you. Perhaps we could just start. What is your current or present position?
I'm looking after my family. I'm at home. But before we go there, although the chair may have made reference to it, is it my understanding that the length of my affidavit and the issues to be raised is appreciated by the committee members, which will not necessarily make it possible for us to complete today. And I'm raising this because I surely don't want to to be here and run through the issues for the sake of running through the issues. It was important for me to provide context in as far as the affidavit is concerned, and also considering the amount of time that we took in consultation and the sleepless nights, Chair, we spent in putting together this comprehensive affidavit. So I will appreciate it if we were not to run through the affidavit for the sake of running through the affidavit, but do justice to the issues that have been raised. I'm not here solely to respond to what Mr. Nkabinde had disclosed. Of course, what he said is the truth, but also there are a number of issues that General Mkhwanazi himself have spoken to that I will want to talk to, that are covered in my affidavit. And maybe, Chair, I'm raising this because just like General Mkhwanazi, we had thought we will be provided an opportunity by the former Chief Justice Zondo. We provided our affidavits because there were issues that were raised. I was given permission to come, but I was never given a date. So the Zondo Commission came and went without me having an opportunity to respond to the issues in the public domain. Which issues remain relevant to the proceedings today? They also are relevant in the Madlanga Commission of Inquiry. And I also thought it would have been good if there was follow through to what the Chief Justice Zondo has said, because he did not make any findings on the security issues. There was a commitment or recommendation made that he's going to recommend to the President to have a commission or inquiry specifically focusing on the security cluster or the justice, crime prevention and security cluster, which let me speak for myself, I welcomed. I thought that opportunity is going to present itself. It never did. So I'm just simply, Chair, raising this to say there is no way that I will be comfortable in going through the affidavit, comprehensive as it is, with evidence in this day alone, because we are not going to do justice. That's my plea. I certainly don't have an issue with proceeding. And in answering your question, I'm at home. I was unlawfully dismissed. That matter is before the Labour Appeals Court. The Labour Appeals Court may pronounce this week or next week, and I don't want to go further into that. That's where it is. Let's allow the courts to pronounce.
Honourable Chair, I don't know if you wish to respond to some of the comments made by General Phahlane. I certainly, I'm not in a position to indicate to you now how soon we might get done. I think you're right that we would not want to rush through your considerable affidavit. It's apparent from the affidavit, and the honourable members of the committee would have read it for themselves, that you remain aggrieved at your dismissal and you wish to raise certain issues relating to that. However, as we've pointed out to you in our engagements and again this morning, that this is obviously not a forum that will be able to make those decisions. They have been, you've pointed out, been raised in other forums, and decisions have been made there. But to the extent that your evidence and what's in your affidavit are relevant to the terms of reference of this committee, we will have a full engagement. And if we are not concluding at the time indicated by the Honourable Chairperson, then we'll come back at another time.
Yeah. No, it's fine. I think it will be fair to give honourable members an opportunity to express themselves on the request for sufficient time by the witness. Can I take the parties, the ANC?
No, thanks, Chair. Chair, I earlier on when you said that we are going to deal with this matter late, we accepted your guidance, but we were a bit conflicted because usually when we start a proceeding like this, we have to prepare as parties, fully aware of the time at which our own engagement will begin with the witness. And so it's going to be difficult to proceed without that plan well known ahead of time. So in essence, I want to propose that we agree with the request from the witness that we should grant him a second day. And therefore, by so doing, it allows us to be predictable today that the engagement is largely going to be led by the senior counsel and his team. As and when the situation requires, we will make our own interventions. But we plan in a way that allows us to know that for today, except interventions, the greater part of the interactions are going to just between the witness and the legal team. I think it will be helpful to plan it in that way. Where I think we may have to decide later, as you said, is which other day can we secure for the witness to come back. But that we agree in principle that it should be today and another day yet to be determined. I want to propose that we consider that approach. Thank you.
The MKP.
Thank you, Chair. I don't think it's a problem, Chair. I think it's understandable. When you read this submission from General Phahlane, it's a very long one. And indeed, it will be totally impossible for us to finish the day today. And I guess the issue now is about the date. You know, when we agreed that when we have to finish, whether it's I think we've got a shocker block calendar for next witnesses. But indeed, with your wisdom, I guess that we will be able to have a date, you know, soon for this submission to be completed. Thank you, Chair.
Okay. The DA.
Thank you, Chair. Must be because it's the beginning of the year. I agree with Mr. Ntuli. Let us deal with the matter in that fashion. And we need an extra day in any event, so it makes little difference. I noticed, Chair, that we're not sitting on Mondays, and I know that Mondays are a constituency day. But given the severe time constraints of this committee, perhaps we should consider sitting on Monday. Thank you.
The EFF.
No, thanks, Chairperson. I really don't know what we're doing and where the consents of the witness come from, because in this committee, we've never rushed through any affidavit. And there must never be such a suggestion that we rush through affidavits. And in this committee, there's never been a witness which left here unsatisfied that my issues were not sufficiently canvassed. And therefore, where that consent comes from, I don't know. When you told us that was going to finish at 9, the chief whip of the ANC and everybody else knew what you were saying. When you said 9, we knew you were talking 1 o'clock or 2 o'clock, because that's what you say. But we are going to finish at 9. At 9, we start renegotiating again to finish at 11, and we finish at 1. That's how effective we are. We are very serious about these matters. So we can't right at the beginning say, it looks like we're going to have a problem. 168 pages does not necessitate anything. It can be 168 pages with few issues that can be sufficiently canvassed, and by 9 o'clock we're done. But this committee at all times, when it is not satisfied itself, it will stretch itself and come to a conclusion that we need another day. But we can't start by saying we need another day, and the reason is it's 168 pages. That cannot be a criteria. This issue which I'm picking up is that the concerns are, I can't just come to rush through the thing, and I'm saying we've never done that. We're going to give this matter the attention it deserves, and by the time General leaves here, you'll be satisfied like the rest of others who came before us here and they left satisfied. Thanks.
Bangazit.
Well, thank you, Honorable Chairperson. I'm inclined to actually support the proposal made by Honorable Dooley in respect of how the proceedings should actually be, taking into account the concerns and the volume of work it would appear that this committee would need to look at. But also there is merit in actually what Honorable Malema is actually saying, that we should not actually put hurdles on our way before we even embark on a journey. We haven't actually started interrogating the issues here. Maybe by 9 o'clock, we would be satisfied that we have done justice to the witness statement, and thereby not necessitating any further extension of time. Well, let's see what happens by 9 o'clock. Thank you.
Honorable Sols.
I support the proposal, Chair.
Okay. General, the committee is saying to you, or you must not be worried that there is any matter that is in your statement that will not be given due consideration. But then, secondly, let's run the proceedings. And at the appropriate time, a determination will be made. If we have exhaustively dealt with everything today, it's okay. And if the committee feels that there is a need for an extension, it will arrive at that decision. So, yeah. All the best.
Thank you, Chair.
Thank you, Honorable Chair, Honorable Members. General Phahlane, perhaps we can, however, get through some of the formalities quicker. And here I'm referring to your academic credentials and your career in the South African Police Services. And if you could just confirm, you matriculated in December 1984. You entered the police as a constable on the 8th of November 1985. In 1982, you obtained a National Diploma, Police Administration. You also obtained a Bachelor of Arts Honours in Public Administration in 2014. And in 1999, you obtained a certificate in Management Services and an advanced certificate in Management Consultancy. Can you confirm that?
I can confirm, Chair.
Thank you. So that's quite an impressive background, and it's of little surprise, no surprise that you ended up in the most senior position in the police services, albeit in an acting capacity, because it also appears from your career in SAPS, which, as indicated, commenced on the 8th of November 1985, that you served over many years in various capacities and in various components that make up the South African police services. You spend time in crime intelligence. You spend time in the detective service, in crime prevention, in visible policing, in human resources, in organized development, in strategic management. You were appointed, you also spent time in communications, and then you also spent time in the senior management services, holding the rank of Lieutenant General, again, which points to you being eminently qualified to hold a senior position in the police. You were appointed on the 1st of September 2007 to the rank of Divisional Commissioner responsible for personnel services. From there, you also held a position as the head of forensic in the forensic division, and until your appointment as the acting national commissioner of police.
It's correct. It will be evident from that I'm not a fly-by-night cop. Many years serving the South African public as an officer in various capacities. I became a senior manager, as the records will show, in 2001. And I'm occupying the rank of Lieutenant General since 2007. That's when I was appointed to that level. So I did not ascend to that level only when I became appointed as an acting national commissioner. It was by the way, I was a temporary worker then as an acting national commissioner.
Yeah.
Okay.
And you, it was on the 14th of October 2015. Sorry, Chair.
No, Chair, I was trying to raise my hand earlier and you couldn't recognize me. I just wanted to ask a quick question, as if you don't mind, that the general mentions the high school he went to, mentions the college where he went to, and then he mentions further studies. But in the further studies, you don't mention the institutions where you obtained those further studies.
All right. I may respond. My bachelor's degrees are from the University of Pretoria, both my BA in public administration as well as my honors degree. I acquired them through the University of Pretoria. My national diploma in policing, it used to be offered by the institution it was called Technicon SA, which when the institutions were amalgamated, became part of UNISA. But that was the institution that offered the qualification. And in terms of the management services and management consultancy courses, which is more system management and organizational development and so on, that's offered by Tshwane University of Technology. When I was there, it was still called TUT, Yeah, I suspect I covered them all. Thank you, Chair.
Okay. You can proceed, Advocate Arendse.
Thank you, Honourable Chair. Yes, just in relation to that question by Honourable Malema, we did ask General for your curriculum vitae, and you said you need to just update it and you'll make it available to us. We've got a copy here, but you make a copy available to the committee members in due course.
Yeah, you must tell the committee, Honourable Chair, that I grudgingly gave you that CV of mine because I'm not a job seeker. I'm not an applicant.
You're not looking for a job here?
No.
Thank you. On the 14th of October 2015, you were appointed as the acting National Commissioner in place of the suspended then National Commissioner General Ria Piecha. And then at that point, did you engage with the minister or the president in relation to your appointment?
In actual fact, it's interesting. I was in this committee when I was appointed in this room. We were making presentation to the Portfolio Committee of Police. General Pierre was sitting somewhere here.
Yeah.
When the announcement was made, Francois Bietman, the former chairperson of the Portfolio Committee, was up there. And an announcement was made that General Pierre is being suspended. For few minutes, General Sithole, who was the Deputy National Commissioner, was appointed by the chairperson to be acting. Not long after that, an announcement was made when I was sitting here that the president, then President Jacob Zuma, appointed me as an acting National Commissioner of the South African Police Service. That was the 14th of October 2015. Appointments at that level are not made by the minister. They are made by the president. He appoints and he disappoints, if English says so.
So you were appointed then by then President Zuma. And on the 1st of June 2017, almost 2 years or so later, you were asked to step down or step aside by the then Minister of Police, Mr. Mbalula.
Correct.
Can you just tell us about the circumstances that led to that situation?
Correct. You will know that I was a guinea pig of the step-aside policy because it was first applied on me for whatever reasons. On that day, I was in Pretoria. I get a call from the office of the minister. I can't remember who specific in the minister's office. And I was asked to travel to Cape Town for a meeting with the minister. I had no reason not to respond to such, made travel arrangements, got here to Cape Town, waited for more than 3 hours for the minister to come. He came. We had our less than 5 minutes meeting. He was there with his deputy. I think the deputy then was Mr. Bongani Mkongi, if I'm not wrong. Yeah, Bongani. So at that time, the media was dominating with Phahlane and Phahlane and IPIT and Robert McBride and O'Sullivan. And then the minister simply asked, General, in view of all this negativity in the media, is it not better that you maybe step aside? I agreed because I'm not glued to any position. And I accepted the role of an acting national commissioner from the president, knowing that as a member of the South African Police Service, you can be deployed anywhere at any given time, as long as it's to serve the people of the Republic. I only asked 2 questions to the minister. Who do I hand over to? And he said, no worries, don't worry about that. And I say, since you say step aside, what does it mean? Say, no, you go home. Shook the minister's hand. Thank you very much. I left. On my way out, I met Mr. Bo Mbindwani, who was, I think, a political advisor to the minister. I was coming from the 9th floor in the building on ground level. As I was stepping out of the lift, Mr. Bo Mbindwani was entering, leading Lieutenant General Mutiwa, a colleague of mine. I left for the airport, waiting for my flight. And it is there, when I was sitting there, that I was following the minister, making an announcement to the effect that I am removed. I was asked to provide reasons within 48 hours why I should not be suspended, and that he is now, or Lieutenant General Mutiwa, who is incorruptible, is now the new acting national commissioner. I was at the airport. Now, I'm giving you all that to say I was not removed by the President of the Republic of South Africa as the Constitution and the Police Act dictates. I was made to step aside by the Minister of Police then. No law provides for such. That's why I continue to say that my removal from office cannot be found anywhere in the prescripts. Later, I think it was on the 7th of June, I then got a call from a colleague of mine, Lieutenant General Skete, who was saying, hey, General, I'm being asked to deliver documents to you. And I said, what is it? I mean, I've worked with General Skete for years. And he said, I've got these documents. It's a notice of suspension. And I said, General, you don't have to go through the trouble of traveling to my office. You can just ask one of the officers in my office. In actual fact, I sent my driver who went to him to fetch the documents and bring them. When I received the documents, the first thing I did, I called General Mutiwa and I asked him, General, are you trying to sort out the mess that the minister has created? And he was very apologetic. He said, General, I'm very sorry. It is true. It's a mess because you never suspend someone verbally without documents. And if I were to be suspended or removed from office, it was to be by the president who in the first place appointed me. To date, I don't have a letter signed by the president which is saying you are being removed as an acting national commissioner. following the first, I think it was the second or the third, there was a media, there was, I can't remember the president's spokesperson, it's Dr. Sam, I just forget the surname. He issued a statement and said, the president thanked me for my services. That's in short what I can say about debt removal. Unlawful, irrational, but it doesn't belong here, it belongs in the courts. That's why I'm ventilating that matter in the courts and the public protector of South Africa.
But at the time, you didn't firstly protest your innocence in relation to the allegations then in the media and in the public domain. You didn't take issue with that when it was raised with you by then Minister Mbalula. You also never took issue with the minister that, according to you, he was not competent to relieve you of your duties as the then acting National Commissioner. And also, you never took issue with the suspension. Is that right?
You are incorrect.
At the time, it's not apparent from your affidavit that you took issue. I'm not sure whether you raised it subsequently. I think you said in a complaint with the public protector.
Because I'm not looking for political intervention or political interference, I don't have to raise issues that are raised in the courts. And I'm not supposed, I don't have to repeat what is being raised with the public protector of South Africa as in ventilating those issues. And I don't see any of such in the documents that the bundle that you have given me here, because it is comprehensive. There was no reason for me to argue with the minister. There is no reason for me to protest. When we serve, I always hear ministers and deputy ministers say, we serve at the behest of the president. The National Commissioner is serving at the behest of the president, not of the minister. So why do I have to contest what need not be contested with the minister? It's not in my nature to protest. I'm not I was never in that mode. I don't protest. I walked away because I don't want any conflict. And I just said, I am not glued to any chair. That is why when I was removed by the National Commissioner, being the Divisional Commissioner, personnel, responsible for personnel, and he moved me to forensic services, I accepted because he was not moving me into prison. He was moving me to go and perform a policing function that I performed very well. It falls within those objects of policing.
Now, subsequently, you were charged and you were required to appear before a disciplinary committee, and initially you did appear on 2 occasions before Advocate Matau, SC.
It's correct. I appeared on more than 2 occasions. And when I appeared before Advocate Terry, there were 11 concocted charges. If you want to have a look at those charges, I'll give them to you and honorable members at some point. But those charges were disappearing day by day because the charges, the people who were supposed to be charged were actually those who were charging me. At that level, when I was in forensic services, I was not responsible for appointing people as senior managers. So now, if you charge me and say you have appointed so and so, go and charge the appointing authority who happened to be the national commissioner then. So those charges were slowly falling away until there were only three charges left. And we were calling for reconvening. My counsel here was representing me. We were calling for the reconvening of that session. It never happened. As we were calling, come the 6th of July 2020, a certain Lieutenant General Reid gets sent by Sithole to me to serve me on new charges completely different from what was there. And concocted by him, Sithole, and everyone. I actually saw in this file, but let me not go there. I'm not the evidence leader. After they concocted those charges, they initiated what was referred to as an expeditious process. Those 3 charges, which were left from the 11, I never had an opportunity to respond to. Frivolous, just like the charge with regard to the expeditious process.
So just to recap, the disciplinary procedure that was invoked the first time, that was in terms of Regulation 9.
No.
Or Regulation 8.
Regulation 8.
Regulation 8. That was the one where you appeared before Advocate Matau, SC. You say there were initially 11 charges, which were then reduced to 3. But in any event, you were never asked to plead to those charges. So those, even though you appeared there on a few occasions, that hearing, in fact, never got off the ground. It never commenced.
No.
Subsequently, the disciplinary action was then changed to Regulation 9, what is called an expeditious hearing in relation to senior management's officers of the police.
No. May I allow, sorry, am I allowed
you
to
must
correct
please
you?
comment. If I don't have it right or I have it wrong, then you must please correct me. You then, that resulted in your appearance before Brigadier Riet.
Lieutenant General Riet.
Lieutenant General Riet.
Yeah.
Yes. That is called an expeditious, what's it, expeditious hearing?
Expeditious process, Regulation 9, yeah.
And that's before him as a single officer, disciplinary officer. Those proceedings are also set out. Can I refer you to the exhibit bundle, item 1, and item 2 is a record of that process. That is the formal notice of this expeditious process. Is that right?
Which one?
The exhibit bundle. Not the big one.
Yeah, I'm on it.
That one, yeah.
Your own exhibit,
Yes,
not mine. Okay.
Yes, our one.
Yes.
Yeah.
It's
right at the beginning. Item 1 is a notice of outcome of the expeditious process on the 24th of. Yes, the first item. That's a notice of the hearing, and the outcome is at annexure G, if you page a few pages down, and yeah.
Sorry, Chair, I'm losing you. What is few pages down?
The first item is called the notice.
No, I can see 1 and 2, the record of proceedings,
Yes.
and then,
Yeah. So it's really just to reference the process that I was referring to, and you were busy trying to correct me.
yeah,
So it's just a matter of process.
okay.
Yeah. So that process took place not in front of Matau, but in front of Lieutenant General Riet. And that was a process that was different to the initial disciplinary process for which you were asked to appear.
Okay. Am I?
Yeah.
So, if I'm allowed, in responding but also correcting you, the expeditious process is not meant for senior managers. The expeditious process is a provision within the South African Police Service Discipline Regulations 2016. And I happen to be the accounting officer together with my former minister, Minister Natin Hleko, that signed those regulations into operation. And that expeditious process is currently being abused while people are spectators. The expeditious process is supposed to be used where, for example, there is direct evidence, something that you cannot contest. For example, we were sitting with an issue of members, somebody who is being arrested in the middle of a cash heist. This member was maybe either the driver of a getaway or he was part of the group. In that particular instance, all what is required is a factual report. When the expeditious process was put in place, it was in inverted commas to make provision for a summary dismissal, because there can never be any justification of a member of the South African Police Service involved in crime, whether it is rape or what. But in cases where there is evidence, there is witnesses where people must be called to either corroborate or deal with the issues, the expeditious process is a wrong process to follow. It is for that reason that I'm saying expeditious process was not meant for senior people. It is meant for all. Now, coming back to me, even the Terry Motau process, let me tell it that way, the one where he was appointed to chair, it was unlawful in my case because the discipline regulations do not apply to the national commissioner or the acting national commissioner. The acting national commissioner or the national commissioner is to be subjected to a process provided for in the Police Act and the Constitution in terms of holding a fitness board. So both processes were not to apply to me. I just said in the beginning, I was removed from office by the minister who was by law not allowed to do so. Now, the question is, when I left the 1st of June, where did I go? I never went to any police office. I've never seen a police office till today. I went to my house. So, if they wanted, they could have allowed me to go to my position as the Divisional Commissioner of Forensic Services and then take action in line with the discipline regulations, because they would have fully and squarely applied on me. Now, I'm to some extent disappointed because I've got a half-baked document here which you say it's evidence. if you look at this document, you will see the first document. The first document is read as document. Then you have here what comes from Mohlala, which allegedly, according to the discipline regulations, is supposed to be an investigation report. No.
General Phahlane, we also do our own research and we make efforts to find relevant documents. These documents have been presented to you and are placed before the committee, not to argue with you. It's to place certain issues on the record. You've made your position clear. It's not apparent, though, from the proceedings before Lieutenant General Riet that you raised that as an objection. But be that as it may, can I move to the next item?
No, but Chair, you can't attribute something to me and move on. That has been ventilated.
Okay. So if you raised it before Van Riet, the proceedings are there before you. Can you point out where you specifically take issue with him and say you are not competent or you don't have jurisdiction to conduct this investigation or this hearing?
It's Chair.
Because I was going to try and speed up matters because subsequently you did approach the Labour Court and that judgment is also in the bundle. Unfortunately, Honourable Chair, Honourable Members, we didn't have time to index or there is an index, but we didn't have time to paginate the bundle. So if I may just ask for some indulgence as we page through this, but there's a judgment of Judge Van Niekerk, one of the senior judges in the Labour Court. General Phahlane, have you managed to get there? It's item 3. Item 3 is the judgment of Judge Van Niekerk.
Chair, if I am to go through this and respond to it in detail, I would have provided you with more information to this. So now we are confusing issues. Judge Van Niekerk's process came after the initiation of the charges. It is me who took the matter to court, and we were arguing a different issue there. We were not arguing the charges.
Yes, you had by now been dismissed.
No, there's no such.
Can we? I don't have time to argue with you. Can I just read from what the judge?
Let me just
can we just read what the judge says?
Which page is it?
It's the third item. It's the Labour Court judgment of Judge Van Niekerk. It's in the exhibit bundle. Have you got it now, General?
I have it.
Yeah. So you'll see from page 2 of the judgment, this is what the judge says. This is an application in which the applicant, that you, seeks in terms of his amended notice of motion to interdict the second respondent, that's the National Commissioner then, from confirming or ratifying a decision taken by the third respondent, that's Lieutenant General Riet, to dismiss him and to declare unlawful and set aside disciplinary proceedings initiated against the applicant in terms of Regulation 9 of the SAP's disciplinary regulations. In the alternative, the applicant seeks an interim order pending the institution and finalization of an application to review. So this is where the judge summarizes your complaint, and which is what you indicated earlier. The applicant's complaint is that the first respondent, the SAPS, is using Regulation 9 to circumvent a disciplinary process already underway in terms of Regulation 8 before an independent chairperson, Advocate T. Matau SC. Then the judge goes on to say the regulations are in the Gazette. They're based on a collective agreement between SAPS and the trade unions. And then he records that Regulation 9 provides for an expeditious process. And as the title implies, it provides for certain cases of alleged misconduct to be determined by way of an expedited hearing. And then in paragraph 3, it deals with some background of how you appeared before Advocate Matau, and your allegation that the SAPS was now acting mala fide, because you can't defend yourself in an unbiased forum, as you put it. So after the argument, the judge dismisses your application and doesn't make a cost order. And at paragraph 10 on page 6 of the judgment, the judge says, in short, the pleadings do not disclose a cause of action over which this court has jurisdiction. So the point is, you were asked to stand down. I'm just summarizing. You were asked to step aside or stand down by then Minister Mbalula. You were issued with a notice of suspension. You were then issued with a notice of a disciplinary inquiry, initially before an independent third party. Subsequently, in terms of this expeditious process, there was an outcome. You sought to interdict the outcome of that process, and then that application was dismissed, and subsequently your dismissal was confirmed. And you contested all of that, but is that a fair summary of the facts?
Chair, while this is not the process where I want to ventilate this, I suspect your reading of the process is wrong, and it will be misleading. We have never challenged the merits of the matter before Van Niekerk. When we went before Van Niekerk, the intention, it was between the sanction and the confirmation. What we were challenging there was because if you look at the record somewhere, if you had obtained the comprehensive records, you would have seen that after Reid arrived at his sanction, which came as a shock, in a finding, not a sanction, we initiated this process because the regulations provides for mitigation and aggravating circumstances. You will not find any mitigating circumstances coming from me because we were challenging that particular process. While we were still waiting for a court day, as usual, they moved on and came up with a sanction. Following that, we accepted that I'm not going to contest this because the correct platform is to go to the bargaining council, which we did. So the Haramse judgment has got nothing to do with the merits. Van Niekerk judgment has got nothing to do with the merits of the matter.
But General Phahlane, be fair to me. So I just read to you a few minutes ago on page 6, paragraph 10. This is what the application was about. He says, the pleadings do not disclose a cause of action over which this court has jurisdiction. It was a technical issue. I accept what you're saying, that it didn't deal with the merits of your matter. I accept that.
You said it's page?
It's on page 6, paragraph 10.
Oh, sorry, I'm looking at the wrong document.
And he expands on it in paragraph 12, where he says in the second sentence on page 7, the applicant appears to indicate that he intends to invoke this court's review jurisdiction in terms of section 158(1)H, that's of the Labour Relations Act, which entitles an applicant to review any decision taken or act performed by the state in its capacity as employer on any grounds permissible in law. So that's his discussion. And then he goes on to say that he doubts whether you have established a prima facie right for the purposes of any interim relief. So it's a very technical judgment. You were the applicant, presumably on legal advice. And from the appearances, you were represented by senior counsel and a junior. And it was to interdict the outcome of the writ process, isn't it? And that interdict was refused. So the writ process, and that's what I want to move on to. I'm not debating with you the merits of your case or the merits of the charges on which he found you guilty. Because we can't resolve it in this forum.
And I don't want it to be resolved here because I'm not looking for political interference. And I'm not going to get stuck in dealing with the judgment, which I'm trying to explain to you. You only go and read what you want to carry across. And I'm trying to explain to you the context. And we have moved on from this judgment. We have accepted that this judgment did not favor us in as far as interdicting the process is concerned. And this judgment had nothing to do with the merits. In reviewing, we went to the correct platform, which is the bargaining council. And it is there where the merits were ventilated. And we talked to it in here, where still the outcome was not in my favor. I then went on to the labor court. Again, it was not in my favor. I am on the doorstep of the labor appeals court. We are awaiting judgment on that one. So I don't want to spend time talking about the Van Niekerk judgment, which was I never challenged it anyway, because I accepted that there is a need to move to the right platform, which is the bargaining council, where the merits and the process were to be dealt with. There are no merits in this particular case.
General Phahlane, at the outset, everybody, all the honorable members, all of us accepted that we will not speed through your affidavit because you're entitled to fully vent whatever views you have. In your affidavit, a considerable affidavit, you spend 9 pages on challenging what you regard as the unlawfulness of your dismissal. So, and we had these engagements over the December holidays with you and your counsel. We discussed the issue of relevance to the terms of reference of this committee. So now you tell me, no, you can't go there and read from what Judge Van Niekerk had to say in this application. That is what I'm doing. If you want to speed through it, then I'm quite happy to agree with you. One, that the Van Niekerk judgment didn't deal with the merits. The first time the merits of the charges against you are dealt with is in this arbitration award, which is the next item, which I want to come to. In that arbitration, the arbitrator upheld your dismissal. You weren't happy with that. You took that on review. It went to the Labour Court. The Labour Court dismissed your application for a review. You asked for leave to appeal. Your leave to appeal was refused. You then petitioned the Labour Appeal Court. That petition was upheld, and your matter was heard by the Labour Appeal Court. I think it was on the 16th of December last year. And that outcome is still pending.
It's not correct. 16th of September, 2025.
So is that a fair summary of where we are?
No, 16th of September.
16th of, what did I say?
December. I was busy with an affidavit on the 16th of December.
September, sorry. 16th of September.
Chair, all I'm saying, and I must be understood, there is nothing wrong to make reference to that, and it is in here. But I've got the problem if you are making reference to that out of context, creating the impression that Van Niekerk dismissed my application, not, and somewhere you mentioned the correct, on technicality, not on merits. And I did not have time to contest Van Niekerk's judgment because it was just not going to take me anywhere. The correct platform was the bargaining council where I went to. And I ventilated the issues there. Whether I agree with the outcome or not, it's a different matter. The matter was ventilated at the bargaining council. Outcome came not in my favor, and I'm saying so in my affidavit, that once that came, follow the process, go to the labor court. Outcome came not in my favor. The same acting judge refused us leave to appeal. It is for that reason that we went to the labor, we petitioned the Labor Appeals Court. And the Labor Appeals Court hearing took place on the 16th of September. When I started, I said, the outcome is imminent. So I really don't have time, energy to waste on the issues that are correctly at the Labor Court. I was here correctly giving an update of where they are, because somewhere you hear somebody, he was fired for the blue lights. I want to know, where is that blue lights? He was suspended for the blue lights. Show it to me.
So shall we move on from there, or do you have anything else to say about your dismissal? Can we accept that the issue of your dismissal, both procedurally and substantively, in other words, on the merits, has been before an independent, a bargaining council arbitrator? It's gone to the Labour Court, and it's gone to the Labour Appeal Court. And until such time as the Labour Appeal Court might rule differently, you have been dismissed by the SAPS in what the arbitrator and the courts thus far have agreed is a procedurally and substantively fair manner.
If that is placing you, let it be. And that's exactly what why I'm putting it here. It's nothing to hide about. I don't find the reason why I should be arguing. If you were to go into the very same issue, don't know why we jump so quick to it.
Because we are going to come to an important issue. Sorry, I see your counsel wanted to.
Sorry, Chair. I was listening to some learned people here behind me. Yeah. I'm all yours.
Yeah. All right. So the relevance though of so we put that behind us now, the issue of your dismissal. The Honorable Committee is aware of the fact that you're unhappy about your dismissal. You've challenged it, but as things stand, as we sit here today, your dismissal, both procedurally and substantively, has been upheld by the courts. And yes, you've challenged it, but to the extent that you now argue or contend in your affidavit that you've been what you call unlawfully dismissed, that has been dismissed by the courts. Can you at least accept that?
What must I accept?
That your complaints and your case against your dismissal has been dismissed in arbitration and by the courts up to now.
The question, and I know I'm here to answer questions. The question is, why do you put that to me while it is part of my affidavit? And that's exactly what I'm saying. I've outlined a process which allows you and the honorable members to have background to that. And I emphasize, I am not here for that. This is a matter ventilated elsewhere. This is a matter that belongs elsewhere. This was by way of background. Where am I? What is happening? Somewhere you started by asking me, where are you working? And I'm saying, I'm working in my garden. I'm at home. Now I'm giving you background. Why am I in my garden? Because I was unlawfully dealt with, and the matter is at the Labor Appeals Court. Let's make peace with that. That's where it is, and go into the issues that need to be dealt with. Part of what I'm saying there, I'm also showing you, giving you even why why I'm even going to an extent of talking the unlawfulness and people in authority who disobeys the laws. I'm giving even annexures. I gave you documents to that effect. But for the sake of progress, I've never came here to say I'm still employed. No, I'm in the Labor Appeals Court. We're waiting for a judgment. So we can move on.
Thank you. Now, one of the big issues that came up in the expeditious hearing and subsequently in the arbitration was the tender relating to the 360 by 180 degree cameras.
Where in my affidavit are you, Council?
Don't you deal with the Itemba tender? You deal with it in your affidavit.
Yeah,
but it's very much at the heart
really
of your complaint.
For me not to be lost, because now one moment we are moving away from the dismissal and so on. Now you go back, because that's part of the reason why this matter is before the Labor Appeals Court. I thought that we have agreed. If we have to deal with the tender,
General Phahlane, let's do like this. The statement that the witness has deposited with us is numbered in paragraphs, isn't it?
Page 18.
I think that is the approach that we must take. If we are on page 18, let's go to that page in the specific paragraph.
It's item capital letter E on page 18. General Phahlane deals with the procurement contract bid 19/1/9/1/187, that the supply and delivery of the 360 by 180 panoramic image capturing system.
Did you get that page, General?
I'm there, Honorable Chair.
Thank you. Let's proceed.
And General Phahlane, you and I had agreed that these court process, arbitration processes, that's now where they are, and it's subject to the Labour Appeal Court now also sitting and considering your application to appeal. But in relation to the merits of the case, that's where I'm moving towards now. The merits of the case, the matter is dealt with fully, not perhaps to your satisfaction, but dealt with fully in the arbitration award, which deals with, amongst other, this particular tender. Do you want me to take you to the relevant passages, or do you accept that this Itemba FDA issue was dealt with in the arbitration award?
No, Honorable Chair, I'm not going to accept that approach. I'm not going to accept to be taken through an arbitration document while I'm contextualizing that issue. Here in my affidavit, it's 8E, paragraph E, and we are from 44 going forward. So we can deal with what I am saying in relation to that. If you want to go and refer to some aspects of the arbitration, because we are saying it here, I'm not going to repeat the arbitration, which we have extensive legal documents before the courts on it, and I'm saying I'm waiting for the outcome thereof. So, to be fair, Chair, I must be spoken to on my affidavit. The issue that the council is trying to talk to is traversed from page 44 of my affidavit, and it goes on. Sorry, paragraph E, paragraph 44. I talk to it not selectively.
Can we understand this? Advocate Adams and General Phahlane. General Phahlane,
okay.
You say that the matters on which you are being questioned are still before the court.
Yeah.
So you are essentially saying to us that the what do you call it, the award of the arbitration award has been appealed.
Yes.
And that the judgment of the Labour Court as well,
yes,
has been appealed. And now we are awaiting the judgment of the Labour Appeals Court.
Yes.
And you argue that it may be unfair to ask you questions on matters that are still lis pendens. That we must wait for the judgment of the appeals court.
No, am I allowed, Chair? No, that's not what I'm saying. Because I have spoken to the issue myself in the affidavit. It is here, paragraph E, from page 44 until page 81. What I've got an issue with is that now I must go through the arbitration award, which I did not even bring here. It is council and them who went to go and fetch it from wherever they fetched it. So because it's something that I've dealt with extensively, challenging that arbitration award, challenging the Labour Court review award or judgment, and the same matter is now where it's pending before the Labour Appeals Court. So all what I'm saying is that don't go and take the pieces of the applications that we are lying there. I have spoken in detail. Now the council was talking about the procurement contract of the what is it, the 360. Here it is. So why must I go and look at a document which the reason why I'm challenging it is because I don't agree with what the arbitrator wrote there. Now I must now go and argue with counsel on something as if I'm before the very same arbitrator. I'm saying, let's talk to it. But here is my affidavit. It's talking to the issue.
You say that those matters are on appeal.
Yes.
Yes, that is the point that we wanted to get, that those matters are on appeal. So we may ask you questions from a wrong premise or from wrong assumptions, because we don't know what the decision of the appeals court may be. If the appeals court comes and upholds your application, we might have made wrong conclusions. Okay.
So, General Phahlane, I was referencing the arbitration award, and I would also reference the Labour Court judgment, only for the purposes that the issue that you raise on page 18 under item E relating to the panoramic system, that issue was dealt with in the arbitration. Witnesses were called. You were entitled to cross-examine those witnesses. You yourself led evidence. You then took that award on review to the Labour Court. The Labour Court also applied its mind to those issues. That is all that I'm trying to establish in response to your narrative, which appears from page 18 on the procurement, on that very same procurement contract, and which runs for a number of pages in your affidavit through to page 32, paragraph 81. That's all that I tried to do. I didn't try to argue with you. I didn't try, and I'm certainly not trying to persuade this honorable committee that you are wrong and that the arbitrator and the Labour Court was right. All I'm trying to say, General Phahlane, or trying to demonstrate rather, is that these issues have been ventilated in what all of us regard or hope to regard as independent forums, legal forums, where you have already given your side of the story, your version. So, having said that, this is your affidavit. We've agreed you're not going to be rushed. What is it now under this item E that you want to elaborate upon or to convey to the honorable committee?
You see, Chair, I refuse to accept what counsel is saying. And I refuse because that's exactly the kind of narrative that has been peddled in the public domain. And I can't, in a paragraph, try and sum up the injustice that I have suffered and the narrative that has been there. Even witnesses in this, before this committee, I was listening to them. They were talking to this 24 million irregularity. I recall, I think it's honorable, but I think it was coming from some members, where they were questioning the submission to the AG to say, can you clarify us on this? That has got a lot to do with this. Facts were misrepresented before the AG, and I cannot just go over this thing. And I took note of what Honorable Malema said earlier. Why the thinking that we are going to be rushing through. And Honorable Malema, unfortunately, this is what I'm being subjected to. look at what I'm doing in terms of that procurement, because somebody went to pay 24 million plus interest to a service provider who did not even deliver a single camera to the police. That happens in 2018, 2019, while I'm sitting at home since 2017, the 1st of June. And that is being attributed to me. That is what I'm dismissed for. To say you have allowed a service provider to take 24 million plus interest, which became 31 million, that decision gets taken in 2018, 2019. I'm giving you here even proof of who signed for that thing. And now I must, in a paragraph, sit here and say, Honorable Chair, I agree with the narrative. I'm not going to agree with it. And if we are to do justice, let's traverse this issue on paragraph E on the panoramic camera. It's not as small. The very same arbitrator that you are referring to misunderstood what is at play here. There was a contract signed. This contract was signed in 2014, 28th of July.
Yes, when you were the head of the forensics division.
Yes. So let's take members into confidence in as far as what this happened and not just narrowly go to this narrative that has been hurting to listen from people who are so uninformed.
I was trying to be of assistance because that's exactly what the arbitrator does.
No, that arbitrator misunderstood.
Sorry.
Wait. Can you take a breath, both of you? I want us to do the following. The General Phahlane has accepted here before the committee that there are unsuccessful bids that he made to overturn the arbitration award. And then the last is the judgment that is awaited from the appeals court. If the matters that you are leading now, Advocate Arendse, are matters that are before the court, sitting here ourselves may not make an assessment or a review of the proceedings in a court of law. And I will want us to move to matters that pertain to our terms of reference. Unless if in those matters there is something that the witness wants to bring before this committee, to say, in terms of the 4 pillars that you have read before me, Chairperson of the committee, that you are investigating, there are the following matters that I want to bring to your attention, and I think they will help the committee to move forward. But I'm reluctant that we should confine ourselves to matters that are now before the court or take much of our time dealing with matters that are judgments or the arbitration award contained in the arbitration award or judgment of the labor court. Because both of you agree that those matters now are on appeal. So I will give you an opportunity. If there is any matter that you think you want to bring to the attention of the committee, which is not a matter before the court as we speak now, let's deal with those matters and allow the committee to move forward. Honorable Nomvalo.
Yeah, no, thank you very much, Chair. Chair, it's a clarity because I want to be on the same page with you. In fact, I was tempted to ask a question when the general raised a concern regarding some questions that are posed to him. Now, Chair, the question is, because my understanding is that to a greater extent, the senior counsel has asked questions in relation to matters deposed on the affidavit for instance, the 360 tender or contract is deposed on the affidavit by the general. So it's not something which is outside and which is now an ambush. And my understanding is that 80% of issues raised on the affidavit are issues which are before court, the contract, because most of those issues influenced dismissal of the general. Now, the ruling that you are giving, Chair, is confusing, really. I'm confused. So how do we identify matters that he should ask and matters that he should not ask? Whereas those matters, all of them, are on the affidavit and were voluntarily put on the affidavit by the general himself. So I'm confused. I just need clarity. I'm not arguing with your ruling. I just want to be on the same page, because we will ask questions after the senior counsel. And when we ask questions, we must comply with the ruling that you have made as the chairperson. So that's where my confusion is.
Okay. No, just to clarify that matter, because it is said by the witness here that the questions that the advocate is asking him are questions that emanate from matters that are now on appeal. That is what you are saying, General.
No, Chair. My discomfort was with counsel going to arbitration awards, wanting me to answer on an arbitration award, which is an issue that we are dealing with. So that's why I'm lost. The document that he's giving me, he's reading from, that arbitration award, even the labor court award, they gave it to me here in the morning.
The arbitration award is under appeal.
It's under appeal, but I don't have an issue in dealing with for example, what led to that. But I've got a problem if I must now write an exam on an arbitration award, which I don't even agree.
You listen to what Honorable Nombalo says. The statements that are contained in your affidavit, you are ready to respond to them.
Yes.
Okay. Honorable Skosana.
Thank you, Chair. Lotshani likupi, General Phahlane?
Ngiyaxolisa. I'm here. And ngiyabonga.
Lotshani likupi?
Asikhona njani?
Siyathokoza.
Thokozini.
Now, Chair, I think what the General is raising is the issue. In fact, I'm going to ask about what I heard now. He said he was given a statement this morning. It's the other one, which it was for the first time you see that statement. That bundle.
Yeah.
You only saw it this morning.
Okay. Must I answer, Chair?
I just wanted to find out, because if I heard it well, he said that he only saw this morning. Am I right?
You can respond, General.
Chair, the documents in here are not foreign to me, but these documents are not part of my submission in terms of annexures, because I have accepted that here I am not in the labor court, or I'm not in the labor appeals court. It has been dealt with there. So what counsel is doing, he brought these copies. Like this is somewhere here, there is records of proceedings. And somewhere I said earlier that unfortunately some of these are half-baked, in that some documents that are supposed to be here, if we want to bring the whole records, bring the whole records and not selective. So I'm now being questioned to say, the arbitrator said this. I say, we have moved on from what the arbitrator said. We have accepted the laws. following the arbitration process. We have accepted the laws following the labor appeal, the labor court. But we are now waiting for a labor appeals court judgment. So why must I go into this? The issues, Chair, they are raised. It's me who raised it. Maybe, let me say, I may have instigated them. That's why they are part of my affidavit. That's why they are comprehensively addressed. So I don't understand why must I go and read an arbitrator's document that I don't necessarily agree with. If we want to have an understanding of what happened, here it is on paragraph, E. It's well captured between E. If you disagree with it, disagree with it. But it captures. Now I must go in, but the arbitrator said this, or an acting judge said this. I hold a view on those people. And that's why I don't agree, Chair. I'm not saying we must not. We must deal with the issue. Because, for example, the 360 camera issue, the 24 million, it's very critical. It's being brushed over. Every time an issue is being asked, even from management, they say, no, but he was dismissed. Dismissed for what? If I'm to be dismissed for 24 million, it's not me. That decision gets taken in 2018, 2019 by a sitting national commissioner who decided to settle with a service provider who laid their hands on 24 million, that became 31 million. That man left the country with that money, unfortunately died. But now they say, Phahlane approved this. How do I approve something in 2019 while I'm sitting at home? The last day I was in a police office was when I left, before I left Parliament. But this is the issue. So I don't understand why we should escape it. Why must we go to a bargaining council thing, which is not talking to the real issue? The same issue is sitting before the Portfolio Committee on Police. I was listening to them, listening to material irregularity. When that issue is being raised by management, no, but the person who was responsible has been dismissed. I listened even when you were at Khoshimampuru, the CFO said so, to say, no, that matter has been dealt with. Whereas the merits are being misrepresented, the facts are being misrepresented. I hope I'm clear, Chair.
It's now 13 hours. We are going to come back here at 14 hours. I want to allow yourselves time. I see you have your legal team here. The evidence leader is with his team. When we come back from lunch, you must be able to help us to move forward in a quicker pace. You had time to consult. When we started here, Matebele, you said to us that it was a marathon of consultations. And I may even need some time to rest. And that's why you requested that at least by 20 hours or 21 hours tonight, if we can allow you that time to rest. So when we come back from lunch, we want to see proof that indeed there has been consultations between you. Can we do it that way? Yeah. And I must say that it rarely happens that in our proceedings, we have this kind of altercation. We always have a smooth running of evidence presentation between the evidence leader and witnesses. So I think the committee has been very patient with yourselves. So when we come back at 14 hours, let's make sure that where you have been missing each other, you would have corrected that and help us to move forward. Thank you.